Good afternoon. Welcome, everyone. I just want to thank you for joining us. My name is Sam Fletcher, and I'm the Executive Director of the New York State Chapter of the National Association of Social Workers. Thank you for joining us for this chapter chat. We are thrilled that you're here, and I'm even more thrilled that we have our presenters today, Mary McCarthy, Ray Cardona, and Elizabeth Felton. And I just want to thank them profusely for joining us and teaching us about this incredible member benefit. And now I'm going to actually hand it over to Amelia, and she's going to walk us through how we're going to interact today, and then she will hand it over to our guests. So thank you for joining us.
Hi, everyone. My name is Amelia. I'm a staff member with the New York State chapter of NASW. I'm just so glad to see everyone here with us today. So I'm going to go over just a few items, then hand it over to our experts and facilitators for today. So I want to make sure, first of all, that everyone who joins us is aware that this program is not a CE program. Chapter chats were designed, right on the onset of COVID, so we could do some social networking while we're physically distancing. So that's the purpose of this program. If you're looking for CEs, we've got them. Our members in the New York State chapter are guaranteed all 36 CEs they need for free. So I'll put that information into the chat box, but I wanted to be very transparent that this doesn't have CEs. So I'm just going to go over the rules of engagement with Zoom. Essentially, we ask that everyone keep themselves muted when you're not talking. Please feel free to chat, make comments, have conversations in the chat box while the presentation is going on. And then once there is a time for questions and answers and conversation, just feel free to unmute yourself. Feel free to continue using that chat box and whatever works for you. I also wanted to make note that you have the option to turn on and turn off closed captioning. So when you hover over your Zoom screen, there's going to be that list of options there at the bottom. The CC, if you give that a click, you can turn on or turn off your live captioning. Also really fun in that area is you can give us a reaction. For me, I have clapping your hands, thumbs up, celebration, and I'm sure there's going to be at some point that one of those are appropriate for our discussion today. So without taking up any more of our time, I'm going to hand it over to our experts for a conversation around the Legal Defense Fund with NASW. Thank you so much, Elizabeth Felton, Ray Cardona, and Mary McCarthy for hosting this conversation today.
Hi, everybody. I'm Mary McCarthy, and I'm going to get us started for today. And I want to add to Amelia and Sam's welcome to all of you. We're delighted to be here and think that this is going to be a really interesting program for all of you. The Legal Defense Fund is really an important member benefit from NASW. And we have a lot of information for you, and then we want to make sure that we save time for questions at the end. So I'm going to start by sharing my screen. And just to go over the agenda for today. So we're going to do introductions. Elizabeth is going to provide us with an overview of the Legal Defense Fund. Ray is going to talk about some case examples. And then we have lots of resources and a summary for today. So to get started, I'm going to ask Elizabeth and Ray to introduce themselves. Elizabeth first, then Ray, then I'll give a brief introduction and we'll get on with the presentation. Elizabeth?
Yes, thanks, Mary. Good afternoon, everyone. My name is Elizabeth Felton, and I'm an attorney and a social worker, and I'm the Associate Counsel at NASW. And I am so pleased to have you all joining us today so we can talk about the Legal Defense Fund. Ray?
Hi, I'm Ray Cardona, and I have been a member of NASW for 47 continuous years, a proud member of NASW. Of course, I was 12 when I joined, so, I'm not that old. But I also have a lot of both macro and micro social work practice. And my last full-time job was actually at NASW as the executive director of the New York State chapter. So that's a little bit about who I am.
And hi, everybody. I'm Mary McCarthy. I work at the University at Albany, and I'm really pleased that I've been serving on the Legal Defense Fund as a board member for, I think, about 6 years now.
Yes.
And have really learned a lot about this member benefit. I've also been the president of the New York State chapter of NASW, treasurer for the national board, and a member not quite as long as Ray, 41 years. So continuously since graduate school. So I'm really always delighted to talk to members and invite those of you on this call who aren't members to seriously consider joining NASW. It's a fantastic association that does a tremendous amount of good work. So I'm now going to turn it over to Elizabeth, who's going to educate us about the Legal Defense Fund.
Okay, thank you. The NASW Legal Defense Fund, and we're going to abbreviate and call it LDF. It was established in 1972 by the NASW Board of Directors. And our main purpose is to assist social workers and the social work profession in defending against lawsuits and to protect legal and ethical principles important to the social work profession. Now, we do that pretty much through our key functions. And one is through Amicus Briefs, and we will talk more about each of these functions as we go on through the presentation. So we participate in Amicus Briefs. We offer the Legal Defense Fund grant, which is financial assistance for social work members and chapters for litigation involving the social work profession or one of the social work principles. We also provide a number of legal resources that are relevant to social work practice. So usually social work and the law will interface with court or some sort of custody proceedings, lawsuits. And so we have a lot of information about the legal resources that the social workers need to be aware of when they're practicing when it comes to subpoenas and HIPAA and a lot of other information. So we're going to talk about that as well. And we also have a legal consultation line. So one of the member benefits is that members can call our 1-800 number if they have a legal question that pertains to social work practice. Now, we do not give legal advice. I want to make that very clear. We cannot give you specific legal advice, but we can give you guidance and information about the issue that you're calling about. And one of our other functions is the SWELI project. So SWELI, there's a lot of questions and issues that involve ethics and the law. So SWELI is a combination of both. And we have projects that we present and develop that can help the members that deal with ethical issues as well as legal issues. And our funding is primarily from the member contributions dues checkoff. When you renew your membership, every time it's due, you have an option that you can hit the checkoff box, and it's a $10 donation that you make when you go and renew your dues. Or you can make special contributions. You don't have to wait until it's time for you to renew your membership. You can just say, you know what, LDF is just such a great resource. I want to go ahead and contribute $25 or whatever you want to contribute. We do not receive any funding from NASW. Our LDF board that Ray and Mary are both members of, we meet twice a year, usually in the fall and usually in the spring. And we have a total of 7 members. And we all get together and we make decisions about any legal defense fund grant applications we have, and we make decisions regarding the legal defense fund as a whole. So I talked about Amicus Briefs. Amicus Briefs are friend of the court briefs that are meant to help a court understand specialized issues and to ensure that a social work perspective is reflected in important cases. So usually we, NASW, will be contacted and we are asked to participate in an amicus brief. Now, depending on the issues that the brief is arguing, we will decide if we have policy statements that relate to that issue, and that's something that NASW would be a part of. So the criteria for filing an amicus brief include the importance of issues and their relations to NASW policy, chapter support, quality of the final brief, and the attorney financial resources required. So normally we have a pro bono attorney that will draft the brief. But the topics in NASW's most recent amicus briefs address conversion therapy, contraception exemptions under the Affordable Care Act, a child's right to legal representation and termination of parental right custody hearings, ICE regulations on the detention of juveniles, Housing Discrimination, Violence Against Women Act, and Religious Exemption Protections and Employment Discrimination. Each brief was grounded in NASW policy as articulated in Social Work Speaks. So we participated in 15 amicus briefs last year, and I'm just going to go over briefly 4 of them. We have about 350 of them online. So some of our most recent briefs, 4 of them were, the first one is Peltier versus Charter Day School, and it involved a Title IX challenge to a school dress policy requiring girls to wear skirts to school. Another case was Segal versus Carrega, and that brief focused on protecting sexual assault survivors from retaliatory defamation suits by their named assailants solely because the survivor filed a police report. So it's re-victimizing the victim all over again. Felton versus City of Philadelphia. This brief involved the Catholic Social Services Department was suing the City of Philadelphia after the city decided to stop contracting with foster care providers that turned away same-sex prospective foster parents. And the case that's we participated in that's important is Boyd versus Gordon College. That particular case involved religious employers using the ministerial exception to try to deny workplace rights, including protections against sexual harassment, unequal pay, and disability discrimination. And this issue in Boyd versus Gordon College was of particular interest to NASW because Gordon College, they were trying to recast social work and social work education as a ministerial religious function. To the next one here. Okay. The Legal Defense Fund grant. So if a social worker or a chapter executive director becomes aware or is involved in an issue, that results in litigation that is related to the social work profession or one of the social work principles, there is a legal defense application grant, excuse me, that you can apply for. You can apply for financial assistance to help defray the legal expenses incurred from litigation. Now, be clear that this is not a lot of money. It's not a large grant, but it's something just to help to defray some of the costs. And the LDF grant applications, they're located at this link. And if you click on the link, it has the information, it has the criteria, and it has what we look for in determining who will meet the criteria for the grant. So chapters and members are eligible to apply for financial assistance with legal expenses through Legal Defense Fund grants to defray the legal expenses from litigations related to the NASW Code of Ethics, social work principles, and or standards of social work practice advocated by the associations. Chapters need to complete a one-page questionnaire for individual member applications. So if an individual member applies for the grant, there is a form in the application packet that the chapter ED will need to fill out. And sometimes the member isn't aware of that, and sometimes the social worker isn't either. So we've had the most two recent examples we had that the LDF board approved of a grant was, one was with the state of, a member from Maryland had some issues with their licensing board. And I believe the individual received an audit of his CEUs, and there was some discrepancy with the record keeping and proper notice issued by the licensing board. So the member hired an attorney to appeal their decision, and based on what he documented, the LDF board reviewed the application and agreed that he should be awarded a grant. The second issue was a member from the state of Indiana. She received disciplinary action based on some allegations that were made against her about breaching confidentiality, but the individuals who made the allegation did not provide sufficient and adequate proof, but yet she was disciplined. So she hired an attorney to appeal the grievance, and the process that was in place at the time that allowed her to be disciplined without the accusers giving adequate information and being a proper investigation. So the requests vary for what the financial assistance, but the board is really good about looking at all the information that's provided before they make a decision. And Mary, did you want to say some more information about that?
Nope, I think that's it. The board really, we get these full packets, the whole application packet comes to us for that board meeting. And then we read through all the materials. We're able to ask questions. We're able to ask Elizabeth if we need more information from the person making the application, to ask for that additional information. And then the board votes in terms of awarding the funding or not. So I think it's really an incredible benefit for members and supports NASW's commitment to the Code of Ethics and ethical practice across the country in all agencies and situations.
And our applications are considered by the LDF board twice a year, in the fall and the spring. And we normally post a due date on the same date we post the application. And I have here the examples. A member of the Maryland chapter appealed the licensing board disciplinary action against his license resulting from an audit of CEU hours. He was awarded an LDF grant to offset legal expenses incurred from litigation involving due process claims. In the Indiana case, a member of the Indiana chapter employed by a state agency was falsely accused of breaching confidentiality without sufficient proof. Based on her lawsuit, the Department of Children's Services has established due process for non-union employees and require evidence of any allegation before the employee receives a reprimand. So in this case, both of her, the second person in Indiana, she was able to prevail in the outcome of her case. Okay, and I think Ray, is that Ray? Or
yeah, thank you, Elizabeth. I have two agenda items. Well, I'm going to discuss briefly a couple of specific cases that have broad implications for the social work profession. And then I'm going to talk about subpoenas, because it's important that we know how to respond to subpoenas. So let me start with Jaffe v. Redmond. Jaffe v. Redmond is about a social worker who was seeing a police officer in therapy who had killed somebody in the line of duty. And as a result of that, his own action, he had really some mental health issues and sought out the help of a social worker. In the meantime, the victim's family sued the city and the police officer personally. And as part of the lawsuit, the family's attorney requested the social worker's notes, and she refused to turn them over, saying that this is confidential and that they do not have to turn over the notes. Well, obviously the family took the social worker to court, and long story short, it went all the way up to the Supreme Court, went through all of the levels of the courts and finally made it to the Supreme Court. And the Supreme Court ruled something very interesting. They ruled that requiring the social worker to give up her notes was tantamount to making her go against her profession's code of ethics, code of confidentiality, and that the court would not require her to break confidentiality. This is so important because in all federal courts, it is a precedent for confidentiality in the federal court system. Now, it does not necessarily apply to state courts. However, state courts generally follow precedents made by the Supreme Court. This case, I believe it was a 1976 case or 77 case, and it still holds to today. So it's a really major victory for confidentiality. Now, that being said, there was a couple of other cases specific to New York which highlighted the Public Law 40, and I have it right here, Public Law 4508. I bet you nobody in this room knows about Public Law 4508. Well, Public Law 4508 in New York state law gives social workers the right to confidentiality, just like a priest and a penitent, and or a lawyer-client relationship or doctor-patient relationship. It's held on the same level as that. And most social workers don't know this, and many attorneys don't know this either. So when I've talked to social workers, I've had them invoke 4508. Very important. Another case that I wanted to talk to you about was a specific case again in New York State. It was involved a Long Island school district who employed a social worker, and the school district sent the school district superintendents put out a memo to all of the social work and guidance staff that if through their work with the youngsters, they find out that a girl is pregnant, that they are to immediately report that to the superintendent, who will immediately report it to the family. Now, we generally want families to know what's going on, but at the same time, if a young woman feels endangered because her family is given this information, we wouldn't want that to go out like that. It would have to be dealt more delicately. And again, so the social workers union, which was the teachers union, social workers are part of the teachers union, sued the school district, saying that they didn't want the social workers should not have to be required to give confidential information to the superintendent. And it went into court. It didn't make it to the Supreme Court, but the lower court rule, and by the way, NASW was very involved. I was at the chapter at the time. We had a lot of back and forth with the attorneys talked to each other, NASW attorneys and the South, the school district attorneys. And anyway, what the court ruled was that they could not go on with the case because the social worker didn't have any injury to herself. So therefore, she didn't have standing in the case. So it was kind of stopped there. But interestingly enough, the court also ruled, in addition to that, ruled that the superintendent overstepped his bounds by issuing that memo. So basically, the net effect of it is that it pushed back the school district from having to from requiring social workers to give confidential information. Very, very important cases in New York. Okay, moving right along, I wanted to talk a little bit about subpoenas. Okay, what is a subpoena? A subpoena is a demand for you to either appear in court or to turn over certain confidential records. So it's very important not to ignore subpoenas. Be sure that you check the date by which you have to respond. If you do not respond, you can be held in contempt of court. I suggest that you also notify your professional liability insurance company. I recommend that all social workers maintain professional liability, even if you work for an agency. And we can talk about that later, but it's important that you contact your liability insurance agency. They will appoint an attorney to work with you. The other thing too is if it's important to contact your client, because the client could give you permission to turn over the records. And if that's the case, then certainly go ahead. You should contact the client and contact the liability insurance company. Let me talk a little bit about witnesses, because sometimes we get called into court as a witness, and it's important to understand the difference between a witness of fact and a witness and an expert witness. So whenever you're asked to testify in court, it's important to ask the question, Am I coming in as an expert witness or a witness of fact? Why is that important? First of all, and if you're going in as an expert witness, they have to pay you. And you can charge whatever you want. You know, if you want to charge $10,000, you can. But normally people charge their actual going rate for court. And then when you go into court, the lawyer would present you to the court as an expert witness, and then the court would ask you certain questions about your background, your experience, and so on and so forth. And if the judge sees fit, the judge will certify you as an expert witness for that case. I have been an expert witness in a number of cases, so I'm familiar with this process. And if they don't want to pay you, they can still subpoena you. All right. But then you're a witness of fact, not an expert witness. And what does that mean? That you only are able to speak to the facts that you personally know. For example, person came to see me 5 times, and this is part of the medical record. Came to see me 5 times. This was the diagnosis. This was the work that we did, the treatment plan, and basically, the only thing you can testify to is what you personally have seen. So if they ask you questions about if it's a marital case, have you seen, the husband and wife bickering or whatever, you can't because you've never seen that. So you're not an expert witness, so you're not testifying to that. I can tell you a very brief story. I got subpoenaed to go to court on a family child separation case, and the attorney, when I spoke to the attorney who subpoenaed me, I went to court and I said, well, I guess I'm here as a witness of fact. And the attorney says, you'll answer whatever questions I ask you in court. I said, well, I certainly will, but I will let the judge know that I'm a witness of fact and not an expert witness. Well, that blew his mind, and he just went away and said, you guys, it's all about the money. Because I wasn't being paid for the day. I was in private practice. If I don't see clients, I don't get paid. So I was able to turn to him and say, well, you're getting paid for being here. Why shouldn't I get paid for being here? He never called me. Anyway, that's just a little aside, a little interesting aside. It's important to understand the difference between an expert witness and a witness of a fact. A couple other points. It's important that you read the subpoena carefully to really understand what they're asking you for. And it's only what they ask you for that you have to turn over, okay? The other thing is who signed the subpoena. If a court clerk or a lawyer signed the subpoena, okay, you still have to respond to it, but you are more liable for breaking confidentiality if the client did not agree to you giving that information over. So you don't want to be charged with divulging confidential information if you get that kind of a subpoena. So you can insist that if the court wants that it should be signed by a judge. And what that does is it lends more weight to your defense of not giving away confidential information. One more last point before we go, and I know our time is running short, but is in terms of what is HIPAA protected. The therapy notes are protected by HIPAA, but not the medical record. So what is the difference between a medical record and a therapy note? A medical record is, the name of the client, the diagnosis, the treatment, the course of treatment, the treatment plan, course of treatment, and ending. And that's basically a medical record. A medical record does not include your analysis of the psychotherapy. So if you start to analyze about the psychosocial dynamics that are going on in a case, okay, that's the dynamic and that's what's protected. However, it's important to note that the only way it's protected is if it's kept in a separate file, separate from the medical record. You have to keep them not in the same folder, not even in the same cabinet, okay? Now with the electronic records, it's important to keep those records separate, because if they're together and the medical record gets subpoenaed, the clinical record has to go with it as well. So if you want to keep it protected, you got to keep it separate. All right, questions, comments, observations? Well, I explained this so thoroughly, there's not even one question. Wow.
I got a private message from someone maybe that'll just help
Yeah,
us.
yeah, go
Okay.
ahead.
They're asking, how do I contact LDF?
Good question.
We have on, I think in the slides to come, we will have links that you can click. But if you go to the homepage and you go under legal, and once you go to legal, it should open up. But I'm not there, but we do have a direct link to that we will provide.
Thank you.
And I wanted to add to what Ray was. Ray, were you all set?
No,
Ray?
I'm done. I'm done. Thank you.
That was really great. I want to emphasize what Ray said. He said it's always important to have your own professional liability insurance, even if you're with an employer that offers it. And I agree 100%, because incidents have come up where a member or a social worker said, oh yeah, I'm covered by my employer, but something happened and the employer didn't support them. You have to remember, the attorneys for the employer, they represent the employer, not necessarily you if you disagree. So she thought that she had the support of the employer, but whatever happened, she got terminated, or they didn't support her. So then she didn't have any representation. So even if you have a job that says, oh, you don't need it, I would recommend that you get your own always. And you want to make sure at the very minimum, they have two things, board complaint coverage and subpoena coverage, because what Ray had said, if you get a subpoena and you have professional liability insurance or malpractice insurance that includes subpoena coverage, then you contact them when you get the subpoena. You call them and say, hi, I'm a policyholder, I received a subpoena, please advise. So I do want to emphasize what Ray had said.
Yeah, that's an important point, that the agency that you work for, they have liability insurance, but that liability insurance covers them, covers the agency, and they will cover the worker as long as Elizabeth said, the client and the worker are, I mean, the agency and the worker are, compatible positions. But the minute that you become, or the worker becomes a liability to the agency, they will drop you. Exactly. With professional liability insurance, you get an attorney that defends you, that protects you, the individual, not the agency.
And I see at the top of the next slide, Mira, the LDF member resources. At the top of that slide, you see the link www.socialworkers.org/LDF. So that is a way to get to LDF. Now I want to talk about the resources. This is a really great member benefit. And so all members, you really should just know that this is out there. On the LDF webpage, we have a HIPAA forms, a HIPAA toolkit. We have all the information about HIPAA that you would need if you're in private practice. So we have a notice of privacy practice. We have sample business associate agreements. We have sample forms. We have risk assessments. We have a ton of information on HIPAA that has been tailored for social workers. So I would definitely say you go and look at our HIPAA webpage, and we are in the process of adding some HIPAA courses to the CE Institute on NASW's website. But right now on the LDF webpage, we do have tons of HIPAA forms. We have a number of COVID-19 legal resources. So when we got hit with COVID, we had a lot of questions about tele-mental health. So we have resources about tele-mental health that includes informed consents, samples, what you need to do, what you need to check in your state, what you need to check with your whoever's paying, the payer, everything you need to do and what you need to know when it comes to tele-mental health. And especially with COVID not ending anytime soon, you should really make sure you're aware of all the tele-mental health requirements that you're subjective to. We also have legal issues of the month articles. We have a ton of articles on many topics: minors, termination, tele-mental health, elder abuse, couples therapy, record retention, supervision, subpoenas. So it really is a short article that talks about it highlights the points that you need to be concerned about when it comes to subpoenas. Everything that Ray has said, you can go get an article and you can see it right there. When it comes to terminating a client, if you terminate a client when they're in crisis, it could be considered abandonment and you can get sued. So we have an article about termination. A lot of social workers provide supervision for supervisees. It talks about things you should be aware of when you are a supervisor, having a contract. We talk about couples therapy, couples and who gets the record. So the legal issue of the month is a number of topics that you may find relevant to your practice that will give you a quick kind of synopsis of the issue and what you should pay attention to. We have General Counsel Law Notes Series. So NASW Press, we have a number of, I think it's about 8 law notes on various topics. And I'll talk about that in the next slide, but you can purchase those from Press. I think they're between $25 and $35, but they're really great resources that you can have and that you can keep and you can refer to if an issue comes up on the topic of that law note. We also have the Social Work Ethics and Law Institute, that's SWELI that I spoke of earlier. And we have CEU course offerings and training. So we offer a number of resources that we're going to give you the links that you can be aware of and that you can tell other members aware of. Their member benefits, you're paying for it, you get it, and it's a really great resource. We also have member-only telephone consultation. So you can call up the legal department if you have a question that's related to practice. Again, we can't give you legal advice, but we can give you some information to kind of point you in the right direction. And we also talked about the Legal Defense Fund grant, and that's the financial assistance to help defray legal expenses. So we're going to talk about each of these. I think the next slides are just going to talk about some of the resources that I just went through. Mary, what's the next one? Okay, law notes. So the NASW Law Notes series provides information to social workers about topics of concern, legal topics of concern to the social work profession, including we have one on expert witnesses, social workers and child abuse reporting, the legal rights of children, alternative dispute resolution, social work and subpoenas, client confidentiality and privilege, the legal rights of students, and the juvenile justice system. And these are all available with NASW Press, and it talks about each topic that's on the law note. That's what they go into in that particular law note. SWELI, the Social Work Ethics and Law Institute. So SWELI was created in 2005, and SWELI supports educational projects about social work ethics and the law. So some of the projects that have been developed was an online version of the NASW Code of Ethics, which makes it so easily to reference if you have any questions. It's like you can just pull it up online. And in 2017, the NASW Code of Ethics was revised, and that was a major project for SWELI. And in 2020, when COVID first hit, we hosted the COVID-19 Ethical, Legal, and Clinical Considerations for Social Worker. So we were just bombarded with a lot of calls, and social worker was trying to figure out, what do we need to do when it comes to COVID? And so we had a webinar that had a lot of information that we offered our members on just how to adjust when COVID-19 had first hit. And what's in the works now is a new project, is Understanding the NASW Code of Ethics 2020 edition, but it is an online, let me read here. It is the NASW's Office of Ethics and Professional Review. It's a 3-hour online course that's built on interactive educational platform designed to engage learners and will include opportunities to learn about ethics and the various NASW resources available to support ethical decision-making. So SWELI is just really great because it allows ethics and legal to come together and address social work issues jointly because they come up in both areas. So SWELI is a great resource for you as well. But the projects and resources that are put out.
And I just want to add to that, because SWELI is independently funded, the board and Elizabeth, when new needs for our members come up that is related to ethics and law, the board is able to really think about what would be ways to support member benefits related to this, and then try to find the funding to help make that happen. So it's a great way to use our.
Yes. So where to find LDF resources? COVID-19 legal resources. These are live links. And if you go to the LDF page, the home page, and then I think legal, and then you hit COVID-19 legal resources, excuse me, and the articles will appear. We have the HIPAA forms and information. Again, you can go and you can download these forms and you can use them and tailor them to your practice. The legal issue of the month articles, we have so many of them and they're so relevant. It gives you just enough information to decide how you want to move forward and what are the questions you need to ask. Law note series, we just went over those. SWELI, here's a link to SWELI, and this is the LDF grant. That's a link to the LDF grant, and then that's another link to the LDF funding application. So I know that it may take a while, you know, to get familiar with the resources, but I think once you go and you find them and you get familiar with them. So from the home page, I just had to go and check. From the home page, you hit, if you go to About, then you hit Legal. And on that page, we have subcategories: legal issue of the month, COVID-19 resources, HIPAA help. And so from that, you can go ahead and find out where you want to go from there. Okay, Ray and Mary?
Just to remind participants that the slides are available, and all the slides have live links to, hot links to these resources as well. Okay, Ray.
Yes. Oh, what am I doing? The resources.
Helping to summarize.
Yeah, I think, oh, okay. Well, thank you. Let me just say about the LDF fund. When I was a chapter executive director, I relied on the LDF fund to help my members, my New York State chapter members, with resources, mostly information, and also a few people were able to get grants. Now the grants are not big bucks, but they are sufficient to help people get over that hump of, you know, needing legal assistance. You know, also the LDF fund also protects the code of ethics, which is a very important tool that we have at our disposal. And like Elizabeth said, the national office, well, you can talk to somebody about legal issues. You can talk to somebody about the code of ethics. They don't give you advice. I mean, each individual social worker has to make his or her own decision about what the code of ethics means in their specific particular situation. However, what the association does, though, is it helps you to make those decisions. It gives you things to consider before you make those final decisions. You know, and so there are numerous resources. I think at one time I heard the number of, there are 7,000 pages in the NASW website. Now that could be overwhelming, but it also is designed so that you can hone in on specific issues of need for education, legal consideration, and so on. So I would kind of echo what Mary and Elizabeth have said about making a donation to the Legal Defense Fund. Your dues does not go into the Legal Defense Fund. That's why they look for a little extra, whatever you can afford, $5, $10, or $100 a year, whatever. It's money well spent. And people have often asked me, like, why are you a member of NASW? It's because NASW does things for me and the profession that I can't do for myself, you know. the legal defense fund, the advocacy in both the state and federal levels. I don't have the time or the energy or the expertise to do that. So I pay my dues for my association to do that for me. I think it's a wonderful resource. And like I said, I've been a member for many, many years and proud of it.
And I just want to echo what Ray said about both the checkoff contribution when you pay your dues. You can actually add money for the LDF and for PACE. So that's one way of making a donation, but also at any point in time, you can send a donation to the Legal Defense Fund. And I think what I've come to see serving on the board is how legal issues affect members every day all across the country in many different ways. They're unpredictable. They happen out of the blue.
Mhm.
You encounter a case, you know, the example that Elizabeth or that Ray gave of shooting happening and the therapist seeing the police officer and then a civil lawsuit following. You know, you take clients every day, you work with clients every day because that's what you do. And suddenly a lawsuit or some kind of legal challenge comes along that was unpredictable and unanticipated. And I think that's where having a service like the Legal Defense Fund that's available to social workers across the country is absolutely essential for maintaining the code of ethics, for really protecting social workers who are out there on the front lines every day doing really hard work. And we don't get paid a lot of money. So, you know, when you do have a big legal bill, it's nice to know that our association is really working with us in a supportive way to make sure that we're protected and our clients are protected.
Mhm.
I agree. And I do see that as an attorney and a social worker, I see now that social workers are being brought in legal matters way more than years ago. So I think social workers need to be aware of how the legal practice can affect your social work practice. And I have had people have called this, said, you know what, I've been a member for years and I never used it. And I'm so glad that I had it, because when this, you know, you're fine until you're not, until something happens. It's like, I've never been called to testify in court. I never got a subpoena. And all of a sudden this custody case, this family you was working with, now there is a custody case and they want your notes of the minor kid that you were seeing. And it's like, oh no, I was seeing a couple and now they're going to divorce. Or a woman is wanting to sue her employer and they want me to testify on her level of functioning. So as far as the court and your social work practice, social workers are just needing to be so aware of their rights and things that can happen to their clients, even with tele-mental health. What does the law say you can and can't do, the vaccine? So there's a lot of questions that social workers have. And, you know, social workers just can't pick up the phone all the time and just let me just call my attorney that I have on retainer. So we can't give advice, but we do offer a great member benefit. And I tell you, for people who have been members for years and have never used it, when they do call that one question, you're just so glad that you were able to get a live person on the other end, or you were able to get a form that could help you set up your practice, or you were able to read an article that gave you information about this topic that you were struggling with. So I having both backgrounds, I definitely see how they intersect. And I just want to empower social workers and let you know, social workers are phenomenal. We know so much. And I want social workers to be empowered that even if you have an attorney, that you understand it as well. And you advocate for yourself the way you advocate for others. So I'm a very strong supporter of social workers having legal information that can help their practice. And so I do definitely recommend that if you haven't checked out our resources, please check them out. And also just consider contributing if you have it. And if you have, thank you for your contribution, because it's a great member benefit. So that's my plug. Thank you, Mary.
No problem. Yay, Elizabeth. And I think you'll see in the chat, someone actually sent you a thank you for a consultation you did.
Oh, wow, that's great.
Yeah, so just our last slide gives you the information about the Legal Defense Fund staff, Ann Camper, who's our general counsel, Elizabeth, who's associate counsel, and our leader extraordinaire, and Melissa is the legal assistant. that really keeps the board in line and makes sure we get to meetings and do our jobs. So with that, I'm going to stop sharing our PowerPoints, which are all available to you, and we'll open it up for questions. And Amelia, have you gathered any questions from the chat?
Yes, I have both Linda and Alice. First, I'm going to give Linda and Alice, if you'd like to unmute and ask your questions yourselves, be happy to have you do that.
Hi, this is Linda. I was just curious, I do use a medical record, and Ray, you were talking about keeping the psychodynamic clinical information separate from the more demographic diagnostic treatment plan stuff. I don't quite know how that would happen electronically. Are you saying to print it off and have paper charts separate?
No, I'm saying if you keep them electronically, you have to have two separate charts.
Two separate folders.
Two separate folders, two separate charts. Can't be part of the same chart.
So if you have a client, Jane Doe, and you have Jane Doe medical records, and then you will have another file or folder electronic that says psychotherapy notes. You have to keep the psychotherapy notes separate from the rest of everything else. So if you keep it electronically, two separate electronic folders. If you keep it a paper record, keep them, and they can't be in the same folder or the same file cabinet, but definitely not the same folder.
So if I've purchased a commercially device, like I use therapy notes, I'm supposed to keep two separate charts.
You're not required to, but you can. Yes, ma'am. Yes.
And so I guess I'd have to check with them about how billing happens and things like that, because the
billing doesn't have to see your therapy notes.
Right.
Right. It can be the same way when it comes to billing. So say you give them everything that's medical record, but you just have something separate with that person's initial that's just psychotherapy notes. It's still the same record. I mean, it's the same client.
Okay, I'll have to ask them how that works.
I noticed on psychotherapy, on therapy notes, which I use, there's both the regular therapy notes, and then there's another section that's just psychotherapy, almost separate. And I never use it separately, but I can see where there is a possibility for that.
Yeah. The problem is if you don't separate them and you get subpoenaed,
I
they get they get everything.
Yeah, I'm just thinking the technology is kind of beyond my brain right now. I'll have to check with therapy notes. Okay.
Yeah.
I had paper records, I did that, but with an electronic record,
it's different, yeah.
Okay.
Linda, just ask your provider, Linda, is there a way you can create a separate folder for each client?
Okay.
So can you create two folders, or however they call them, two files for that same person?
Okay, thank you.
And we do have a legal issue of the month on psychotherapy notes. So if you go to the legal issues of the month, and I will find out what the date and month of that is for you before.
Thank you very much.
Alice, go ahead.
I had a question with regard to, I've had a police applicant that I've been seeing since he was a teenager, actually, and now he's an applicant for the police department, and the police department, the application bureau wanted to see all of his notes, and I first gave them the regular information, but then they said no, they wanted the complete, all of his note, and he signed for that. I did that, but it seems somewhat inappropriate. What's the status of that situation?
I would say whenever you have cycles, and maybe I'm getting the echo. Whenever you have a client and they are submitting, there's a request for their records, always let the client know that you received a request for their records. If you have a copy of it, email it to them and let them say, hey, client, I received a request for a copy of your records. Do you give me written authorization to comply? And I would also say for psychotherapy notes, this is very important. I need to find an article. Psychotherapy notes require a separate release. So you can have, if a client says, yes, give them everything, you can have the release, the general one that they send, but you always have a separate one for psychotherapy. It's by itself. Nothing else can be on that release. And the client must initial that they're giving a written authorization for those psychotherapy notes to be released. So even if they gave a general one, you always follow up the psychotherapy notes. So that is, the psychotherapy notes have extra protection. That's what Ray was talking about with the case. They have extra protection. So one thing, if they're requesting the records, you give them the medical records. When they say, I want everything, you make it very clear. Client, you understand we're talking about psychotherapy notes? Okay, please sign this release.
The one I use is the one that I actually got from NASW, which has a separate thing that says psychotherapy notes, and he did handle it, and he said that was all right, but it did give me great concern, you know, and you know, I've never had to do that before, and it just it didn't really feel right, you know.
We've had if you have some concerns about the you can say, hey, client, I understand that you've given me permission to give your records, and I just want to make you aware. And you, if you know it's something really sensitive that maybe the client has forgotten about, you know, 2 years ago, you went through a really rough time. Do you know all that's going to come out? Now, you don't give legal advice, but clinically you can say, I just want you to be aware that this clinically may, you know, be traumatic for you, or it may set you back. So if you have some clinical concerns, it's okay to say that, even though you're still going to comply with the request, but whatever your concerns are with the client, you can let them know and say, hey, I understand you want this, but I just want you to aware, you may have forgotten, there's some sensitive things you told me about. Do you remember? Are you sure you want them to get this information? Other people can say, you know, I don't want any parts of it. Another way you can give the records to the client and let the client give it to whomever is requesting. Sometimes therapists, they don't even want to be involved with it because they don't feel comfortable with that. So you have to make sure if the person who's asking is okay if the records came from the client and not you directly.
So in other words, it's not unusual for something like that to happen then?
Usually, yeah, attorneys tell their clients that you can have a stronger case if you can show damages, which usually will be the emotional damage or documented in the clinical record from the therapist. So sometimes they are encouraged to go seek clinicians so they can show that you have PTSD, and they want the records to kind of corroborate their case. So it's not uncommon, but it doesn't mean you're okay with it clinically. So that's why I was saying how the social work and the law, a lot of times clients are told to come to therapy to help their case. And you may not think it's in their clinical best interest. Okay,
you know, this discussion makes me wonder about having a separate discussion on what to put in your notes, you know, because a lot of lawyers or social workers suggest that you don't put any factual information in your therapy notes, just assessment, you know, because it's the facts that the courts are looking for. So it's just, but I think this is part of a whole separate chapter chat.
Yeah, because you have to make sure your notes are, they're your records. So they have to meet medical necessity. They have to document what's happening with the client. You have to be comfortable. So they have to be clinically sufficient as well. So I do believe that a lot, you really have to consider, because I know some people say they don't want to put a lot in it, and other times they do. And I just think you have to make sure your record is complete so it covers your client and it covers you as well. Now, what that entails with everybody is going to vary, but I see some people go the other way and they try to be so spare and don't include anything, but then the records aren't really helpful, and they should be, you know, they have to include a lot of information for different reasons, insurance purposes, you know, if a lawsuit happens, sometimes clients need your records for disability applications. So your documentation is important. But I do believe if you keep them separately, the psychotherapy notes, you can really kind of get that. And it's the legal issue of the month from June 2006. Let me see if I can put it in the chat box. But that is the one that talks about the psychotherapy notes. And it's really important that you understand that distinction. It's June 2006. And it gives an example of what is a psychotherapy note and what is a medical record.
Great. So when I was seeing clients privately, I always used to limit my records to what's called a SOAP note. I don't know if people are familiar with a SOAP note. Subjective, objective, plan, and subjective, objective, assessment and plan. Assessment and plan. And that's just a minimal note, and that is sufficient to for the medical record. And any other psychodynamic or psychosocial assessment that I made went into the HIPAA, into the therapy notes.
And make sure for your billing purposes, is that enough? If you're in insurance panels, is that documentation enough for them as well?
Yeah.
And we do have sample forms. We have the sample, a sample mental health authorization that shows how the psychotherapy notes need to be set
up. Yeah.
Separately authorized.
So I'm aware that we're over 1 o'clock now. Amanda, were there additional questions that you found in the chat?
We have a lot of comments of thanks, actually. I think people were happy to be able to engage and have this as a resource, but mostly I think that our members and non-members who are here with us are really thankful for the time and effort that you put into this presentation, but also the Legal Defense Fund in general. So thank you, the three of you, for doing this work, especially, you know, I know Mary and Ray are both members who do this as volunteers, which is so important that our members are embedded into the resources that we have. So I'm going to see if there's any last questions. And other than that, what would you guys like to share in closing?
Really just thank you, and a particular thanks to Elizabeth, who's our expert, who's doing this as a volunteer as well from Maryland. So we're really grateful to her and her leadership for the Legal Defense Fund. I think as an association, we're in great hands with someone with her skill and expertise. And we want to thank all of you for your service to our clients and communities and families, and for all the work you do every day. And Sam and Amanda for giving us this platform. So thanks, everybody.
Thank you.
Yeah, I would like to echo what Mary says, thanking everybody. And I would just like to kind of add that if there are non-members on this call, I would seriously consider, I would ask you to seriously consider joining the association. It has been a tremendous resource on many, many levels. And if you're a student and you need a student membership, it's certainly something you can ask your family for a birthday gift or a Christmas gift or a holiday gift as a membership. So anyway, thank you all.
Thank you.
Thank you, everyone.